the post. I'm using it in a different context. So if you're scraping, and that's kind of the heart of the New York Times case, and one of the issues.
Gotcha. Go ahead, explain that case, because I vaguely understand it, and I know you're going to make it sound crystal clear.
Oh my goodness, I will try. So OpenAI and Microsoft are getting sued by the New York Times because they have allegedly done scraping and have used the content that New York Times has published online to train their GPTs.
Okay. Now, was that so? My understanding is it's not like they put an entire article out for the public, but they may have put a snippet, and then some other people are quoting it, and so all of a sudden it can be recreated, even though it's behind a paywall. Is that part of that as well?
And that's part of what the arguments are. Is did OpenAI, because OpenAI is the developer of the models, did they actually go to the New York Times site and actually scrape full articles? Could they? Or was it behind a paywall? And so I'll stop right there and just pause for there, because I'm actually teaching a cyber law course for a law school right now. And just last week I was discussing Trespass to Chattels, which might not sound like anything to you all, but it's essentially this concept of, if I'm browsing an internet website, what are the rights that owner of that internet website has to prevent me from taking content, scraping it? And so it kind of gets into the heart of, go ahead.
What'd you call that?
Trespass to Chattels. It's like a...
Trespass to Chattels.
Yes.
Okay.
Yeah. So it's essentially this concept of, if you think of property, it's a area of property law, and torts or harms that you suffer. And trespass is one of those. And so if someone is coming onto your site, which is your property, and taking content from that, is that illegal? And right now, we don't have a lot to go off of, because that's not the only question that has to be asked. If something's publicly accessible on the internet, the Supreme Court, in a case called Van Buren, said that you should have this concept of gates up, gates down, which if you have your website gates are down, anything can be accessed, then arguably it's fair. It's fair for someone to come and scrape that content and use it because it's publicly accessible. Okay. However, if you have it behind a paywall, like the New York Times, that is a protective measure that they're taking. And there are a lot of questions left unanswered by that case, such as, like, if your terms of use for the website say you can't scrape, is that sufficient? So it kind of, it's a lot to unpack in that sense, but that's there's a lot of previous internet law history that comes into play in this new realm that we're in, of the importance of either being able to legally or illegally, whether it's legal or illegal, to scrape content from the public internet. Because one thing in particular is whether it's considered a harm to the host of that content.
Yeah.
Well, you could sit in the case of the New York Times, if you scraped, like if they paid a subscription and then went and scraped everything behind the subscription, you're definitely harming them.
So this is where it gets, I love talking about this case, because the irony is just lovely. So Microsoft owns LinkedIn. LinkedIn, you have to have a user account to be able to see the data.
Yeah.
They actually sued a company called HiQ. They sued them because HiQ was scraping public profiles, and maybe there was a case where they did actually create accounts to go and scrape profiles from LinkedIn to build a database. And you can imagine the benefit of that to businesses, to have a database of people's current jobs. It's like, voluntarily you put that out there.
Yeah. And you don't have to show them that you were looking at their profiles.
Right. And so I love the irony of it, because LinkedIn was involved, which Microsoft owns, was involved in suing them out of business, basically, for scraping. And it's a great case to look into, because it dove into those nuances of what Van Buren started, and kind of the nuances of what does it mean to have a gates up, gates down, where terms of service come in. And in that one too, it's also important to think about, like, the data is not really copyrightable data, because it's personal information. You can't copyright personal information. It's hard to claim ownership over that.
But you're definitely hurting the LinkedIn business model and the people, and the investors in that company.
Or the expectation of users, because I guess LinkedIn could argue, like, if I'm a user of LinkedIn and LinkedIn has done nothing to stop this, I don't want to be on LinkedIn anymore.
But to your point, LinkedIn is a definite gated community.
At this point, yes.
Yeah. So how do you think that from this perspective, or from this point in time, like, how do you think the New York Times thing is going to play out?
Ooh, that's a good one.
Be a judge.
So there's also another case that is Authors Guild related, where authors are suing because
I've
their
seen-
content's been scraped in. It's interesting when you think about it from the perspective of studies that are coming out now. And I try my best to read and get a holistic view, but it's impossible to keep up with everything every day. But I've looked at a lot of studies, and it's this concept of, and I beg the question myself, when you're training a model on pre-existing, I call it pre-existing materials, because I think it's. Side note, if you're working with model cards or data provenance, I prefer to use the term materials because I want to understand it's not just data. It's also, it might be PHI. I think it's important to name what you're
PHI is
working with.
personal
Yes.
health information.
It might be personal health information. It might be personally
Yeah.
identifiable information, PII. It might be copyrighted information or information that is protected by copyright laws. It might be public domain information. It might be subject to Creative Commons licenses. All of that kind of stuff. It might be subject to open source licenses, which is what GitHub is dealing with right now in one of their cases.
Like it could be sensitive in some way, shape, or form.
Right. Sensitive or protective or proprietary. And so that's why I think as someone who's advising teams on use of data sets and use of models, to me, it's important from a risk liability perspective to understand, okay, what is the liability of engaging with this data set and reproducing it? Because that's what some of the lawsuits like on the image generation side for Midjourney and Stability AI,
Yeah.
a lot of them are involved in cases. There's over a dozen now copyright cases surrounding this. So we can go on and on. But those in particular are looking at the Lion data set out of Germany, which is a data set which is just links to images online. And it has the associated description and kind of stuff like that. But in order to use that data set and have it to build a model that can become like a Midjourney type model where you can do the fun text image generation, you have to copy the data. You have to copy the images from those links onto your own server
Yep.
in the cloud, arguably, and then use that to train and build your model. And so that's the act of infringement in a lot of these cases that we're seeing is they're claiming that act of copying is unauthorized. You're making a copy of those images from the internet without the permission of the owner of those images, and you're using them. And so that's when also we're going to see this argument play out of whether that's a fair use defense or not. And then it's this other question of when the New York Times specifically, just because something is publicly available online, is that going to mean it's fair game to be scraped and to be used, or is it going to be limited to what's just behind a paywall where you have to license it and it's proprietary at that point?
So you didn't answer the question, though.
I know. I try not to share my own viewpoints on
Okay,
this.
okay.
But no, I don't mind doing it. But I think,
will, though.
I will say I'm torn. I recognize the immense value. So kind of where I fall is as of right now, my views are subject to change.
Sure.
I view it as impactful on creative industries and creators to be able to have someone that can scrape something that they've put out on the internet.
Yeah.
Because that's the nature of the internet. You put it out there for public consumption. If that means that can just be scraped and used up by somebody that's going to then create a product, an AI model or a service that allows others to basically not come to me for that same image or come to me for a similar need, what does that mean in the future of creativity, in the future of the world? Because to me, that kind of is a harm in that sense.
Yeah.
But outside of that, what if you're building a security system to recognize images and objects, and that is, do you still need to license all of that, or because it was publicly accessible, there's not really a licensing model for that anyways? Is that fair game because it's a completely different industry? It's not impacting the underlying rights and market for that original content. There are a lot of holes you can poke in either direction, but yeah.